Very much, Chair. It's fantastic to have you chairing this meeting today. Could I also congratulate my honourable friend, the member for Wolverhampton South West, for securing this debate and working so hard for her constituents. And I know her eagerness to secure this debate comes from an anxiety, a real anxiety about what will happen to all of those workers. I suppose I'm just wondering what is wrong with the model of directly employed workers delivering contracts on behalf of the government on such vital projects like schools or hospital builds, on maintaining our prisons, workers who would have access to trade unions and trade unions to the workers, employers who afford their workers rights and protections, and work which sees them live a good life in security. A model where any profits made from the workers' labour would be reinvested in the wages of the workers and the projects the nation needs. What we saw in Carillion was the absolute opposite of that. Not only are Carillion well-known blacklisters, in the years from 2009 to 2016, it paid out £554 million in dividends. That is 3/4 of the cash it made from operations. In the 5-year period from January 2012 to June 2017, it paid out £333 million more in dividends than it generated in cash from its operations. And we know that in the last 6 months, Carillion issued 3 profit warnings. We also know that during that same period, as has been mentioned, following these profit warnings, Carillion was awarded 3 contracts worth nearly £2 billion. Now, I know that the Conservatives and others and those wedded to freedom of the market would maintain that a business does what it wants with its profits, essentially. It's up to them, and there should be very little state intervention. But surely even those people, just let me finish, because you might agree with this point, but even those people can see that paying out more in dividends to shareholders than you make in profits, paying out 3/4 of cash made from operations in dividends is not a healthy way to run business. Would you still like to give way?
Thanks to the Honourable Lady for giving way. And I do agree with her last point. But the description, the kind of description she gave to what Conservatives believe in general about the marketplace, I think, is a fallacy. We believe very much in the operation of markets, but within a framework of law, and directors of companies have serious responsibilities, both legal and moral, for how they conduct their affairs, and that accountability is framed by the law that regulates the marketplace.
Thanks for explaining to me the nature of conservatism. That was very welcome. And I think the contracts after 3 profit warnings tells its own story. It's catastrophic for workers, and it damages the progress of desperately needed public infrastructure. Imagine all of the investment that could have happened if even half of that money going to shareholders was invested in public projects and workers. That's why the Labour Party calls on the government to bring these contracts back in-house. The situation we have today with potential mass job losses is not the fault of the workers. Therefore, a degradation of workers' rights as a result of the collapse of Carillion, where 20,000 workers' futures were thrown into chaos, and worry is a price that they should not have to pay. The government is not powerless in this situation, I would argue, given that it has 450 contracts with Carillion. It's a major customer, or was a major customer, of this company, and therefore they have a considerable stake in the future of those contracts and what the new jobs will look like. I would hope that at the very least, if there is any doubt that TUPE applies, and particularly Regulations 4 in relation to protection of contractual rights, and Regulation 7, the protection from dismissal, that there should be a Cabinet Office statement of practice issued to ensure that all employees on Carillion public sector contracts are transferred as if TUPE applied. This statement of practice should also apply to all contracts relating to central government, local government, the NHS and all public bodies. And similarly, for those people working on private sector contracts, could the government not instruct the official receiver to transfer employees on private sector contracts as if TUPE applied? The government instructed the official receiver to prioritise the continuation of public sector contracts, a good thing. And I think, in addition, it is right to give similar instructions on behalf of private sector workers whose livelihoods are no less important, as we all know, than those in the private sector. It's extremely important, too, that where workers do transfer to a new employer, their individual contracts of employment and trade union recognition arrangements should follow with them. We know so far that 980 workers have been made redundant, 7,500 have been transferred. But after all these weeks, thousands of workers still face great uncertainty, as has been told in personal stories and constituency-based stories. And the government, alongside the official receiver and the special managers, must provide that certainty now. I would like to know, for those employees who have already been transferred, because the government said that the majority had been transferred on similar terms and conditions. What does majority mean? Is it 51% or 99%? And what does similar mean? And I don't, with the three Conservative members in the room, I don't want to be accused of being overtly sceptical, but the government isn't hardly seen as a bastion of workers' rights, and therefore it's unlikely that similar in this equation would equate to an upgrading of workers' rights. And for those who were not transferred on similar conditions, what was the degradation of their terms? I'd like to know that, please. The full scale of this catastrophe cannot just be forgotten as another failure of outsourcing, especially when, rather than resorting to an alternative model, a wholesale alternative model, the government are simply allowing a similar operation to bid for contracts, which really concerns me in the long-term security of these jobs. I would therefore like to ask the government, how are they going to track the outcomes of Carillion workers in the long term of their new employment and training places for employees, as well as self-employed people of subcontractors? Now, as the government will know, Regulation 13 of TUPE, which places a duty on the official receiver and special manager to inform and consult employee representatives in relation to TUPE transfers, is still a requirement, even if Regulations 4 and 7 do not apply. Therefore, it's very, very important in setting workers' expectations and giving clarity about their future. This regulation is very important for that reason. It relates to information about the transfer, whether that's actually going to take place, about the date of transfer. It relates to its legal, social and economic implications for any affected employees, and the very fact that the transfer will take place, as I've said. Now, I want to know, have the official receiver and the special managers been complying with this duty? That's not clear. Are those representatives being informed and consulted with? I worryingly read yesterday too that Unite the Union has also discovered that Carillion didn't pay into the NHS pension scheme in December 2017, even though deductions were made from employees' salaries. I would like to know what has happened to those pension contributions. My final point is this. I think there could be an argument that Regulations 4 and 7 do apply in the case of Carillion. I understand that the usual position when a company is put in a compulsory liquidation is that trading ceases and operations come to a complete halt. In an ordinary liquidation, priority is given to paying off the creditors, and therefore Regulations 4 and 7 do not apply. In Carillion's situation, the government made it clear, very, very clear to the official receiver, that they should instruct some of Carillion's companies to continue with their operations, especially when that relates to public sector contracts, so that services being provided by Carillion could continue without a break in service. The Minister for the Cabinet Office said himself, "Let me be clear, all employees should continue to turn up to work, confident in the knowledge they will be paid for the public services they are providing." The official receiver's decision that some Carillion companies should carry on trading to safeguard and maintain the services they are providing means that the liquidation has been conducted in the same way as administration, in which Regulations 4 and 7 would undoubtedly apply. And if you don't believe me, because the Minister was shaking his head, I'd like to point the Minister to the Dosuro case. Now, that was my Northern Italian, right? So I'm happy to provide the Minister with my notes after this. The case considered whether the Italian version of TUPE applied to transfers effected by a company which was subject to special administration procedure for large undertakings in critical difficulty. The special administration procedure had many of the same features of a compulsory liquidation. Nonetheless, the Court of Justice decided that the Business Transfers Directive could apply if it had been decided that the undertaking should continue trading, for so long as the decision to continue trading continued in effect. Thank you very much, Chair. I thought I'd done something wrong or was being outrageous or something, but there was a division. So I was pointing the Minister to the case in Italy, where the Italian version of TUPE applied to transfer effected by a company which was subject to a special administration procedure for large undertakings in critical difficulty. The special administration procedure had many of the features of a compulsory liquidation. Nonetheless, the Court of Justice decided that the Business Transfers Directive could apply if it had been decided that the undertaking should continue trading, for so long as the decision continued trading in effect. I would just urge the Minister to look at this case and consider the application in Carillion's case, because there are so many similarities. Chair, I think where there is a will, there is a way. And whilst the political questions highlighted by Carillion are absolutely crucial, and the modelling of outsourcing to companies which essentially leak taxpayers' money to rich people to make them even richer, and those same taxpayers who fund the obscene wealth of these shareholders, face joblessness, degradation of their terms and conditions, and a race to the bottom in what right they will have left. We know that that model has had its day. I'm not sure the government does. But the critical question today is what happens to these workers, their jobs, their pay, their terms and conditions, and their security. I just urge the government to take decisive, reassuring action for thousands of these workers and answer some of those critical questions we have all posed here today. Thank you.